How does a holographic will work for your will? Have you ever wondered how a handwritten will can hold up in the eyes of the law? Today, we are going to talk about holographic wills and how they can work for you. A holographic will is a unique type of will that is written entirely by hand and signed by the person making the will, known as the testator. This document expresses how the testator wants their estate to be distributed after they pass away. One of the standout features of a holographic will is that it does not requiring witnesses or notarization to be valid. However, the acceptance of these wills can vary from state to state. This means that while some states recognize them, others may not, so it is important to check the laws in your area. To be considered a valid holographic will, the document must meet specific requirements. First, it must be completely handwritten. If any part of it is typed or printed, it will not qualify as a holographic will. Next, the testator must sign the document to confirm that it is indeed their will. Additionally, the will must clearly state important details, such as naming beneficiaries and specifying how assets should be distributed. Another essential aspect is testamentary intent. The document must show that the testator intended for it to serve as their will. Furthermore, the testator must be of sound mind when creating the will, meaning they understand what they are doing and the consequences of their decisions. Since holographic wills do not have witnesses, some states may requiring additional proof during probate. This could include testimony from people familiar with the testator's handwriting or even handwriting experts to verify authenticity. The lack of witnesses can make these wills more vulnerable to challenges regarding their validity or the testator's mental state. For older adults, holographic wills can be an appealing option. They offer a simple and quick way to document wishes without the formalities and costs associated with attorney-prepared wills. However, there are risks involved. Not all states recognize these wills, and ambiguities or incomplete instructions can lead to disputes or unintended outcomes. If an older adult decides to create a holographic will, it should be entirely handwritten, signed, and dated. They should clearly state their intentions regarding asset distribution and keep the document in a safe place where it can be easily found after their passing. Consulting with an elder law attorney can help clarify whether a holographic will is appropriate based on state laws and personal circumstances. In summary, while holographic wills can be a straightforward option for some, it is essential to understand the potential risks and legal nuances involved.